Good morning, everyone. I'm Tatia Davenport, CASBO CEO, and I want to welcome you to the webinar on 2024 Labor and Employment Legislative Update. We have a very crowded house this morning interested in all of the new legislative changes that are affecting our school districts and the public entities in California, and focusing on those implications to school business operations. Our expert, Eric Barba, partner with Lozano Smith, is going to guide us through these updates and help us understand how they can impact our strategies and our compliance requirements in the years ahead. So we're going to begin by exploring these critical developments. I will let you know that most of our time this morning, in terms of the presentation, there's a lot of content. We're going to spend a lot of time on the brand new developments. We're going to dig into those, and we might be, easing through the content at the end. And we're sort of, again, prioritizing it that way. So we will ask, and this is important, that you put your questions in Q&A. I expect there will be a lot of questions, and we want to be able to follow up with you on getting those answers. Certainly, you're going to have Eric's information available to you, but put your questions in Q&A, and we will take them as we can through our limited amount of time. We are recording this session and intend for that to go out today, so please know that. And without further delay, I want to introduce Eric Barba. Thank you for being here, and thank you for the support of Lozano Smith in bringing this information forward.
Yeah, thank you very much for having me, and good morning, everyone who's joining us from up and down the state and from perhaps parts further afield. Again, my name is Eric Barba. I am a partner with the firm Lozano Smith, and it is a distinct pleasure to be able to share a legislative update with all of you school business officers and human resources officials. I will caution and reiterate a note that there is a lot of content that we will be covering today, but don't fear, you will be provided access to the presentation slides so that you can cross-reference any of the code sections that we do talk about today, to the extent that you have any pressing questions or want to follow up. Additionally, my contact information will be made available if you want to reach out to our firm just for any brief follow-up questions about the content of the presentation. And then, of course, there may be many specific questions where you do need legal advice. We'll always encourage you to reach out to your trusted legal counsel to address any specific issues as they pertain to the operation of your school district. Again, in terms of logistics, and before we jump in, because of the amount of content involved, by necessity, we will have places where we do a bit of a deeper dive, perhaps because of the recency of the legislation involved, or because of the perceived impact that we see in your operations. And there may be other pieces of legislation that have been adopted within the past couple of years or so that you might likely be more familiar with, that we'll do a brief refresher on, but perhaps move more quickly past in order to save time for much of what we have for you today. So again, don't take the amount of time that we spend on a particular item to mean that it is or is not important. It's just a matter of our limited time today. And again, there's always time for follow-up, so please take us up on that. Without further ado, I'm going to share my screen and the presentation slides. If you can just give me a thumbs up if it's all readily available. Is that visible? All right, so we'll jump right on in. And here's a brief overview of the content that we'll be covering today, beginning with the newly enacted AB 2534 regarding disclosure of CTC report information to potential employers of certificated staff. So we start here because this is a piece of legislation that was signed by the governor in the past couple of months and is due to take effect January 1st of next year. This is one of these items that you look at and you see, well, why would anyone ever be opposed to that? And you'll note from the presentation content that in fact within the legislature there was hardly any opposition, if any opposition to the bill, because the underlying premise here is that the legislator is seeking to make it easier for school districts to share information with each other regarding certificated applicants who have been reported to CTC for egregious misconduct. The caveat that's going to take place here is that while a great idea in theory, and ultimately I think a positive thing for folks in the education space, uh, it's going to create a lot of operational questions, and it's going to create a lot of work up front. And there are spaces in the way that the legislation is written that will require some cleanup in the future. So as we discuss this in general terms, it's going to sound great, and in fact, it is great. But there are going to be a lot of questions. There's going to be some speed bumps along the way as you operationalize this. So we'll go into that. So broadly speaking, we'll start with what existing law currently requires. And under Ed Code section 44939.5, school districts who have made a report of egregious misconduct about a certificated employee to the CTC are required to report the fact that they made such an egregious misconduct report to CTC if they are requested to do so by a potential employer. So if you receive an employment verification and they ask specifically about CTC reports for egregious misconduct, per this Ed Code statute, you are required to notify the requesting school district. Let's take a step back and note that this pertains to a very small sliver of conduct that may have been engaged in, right, by your certificated employees. This pertains to egregious misconduct, specifically as it's defined in Education Code section 44932. So in general terms, those are sex crimes and offenses, controlled substances offenses, and offenses involving child abuse and neglect, right? It's very narrowly delineated, and there are instances where you are required, right, by regulation to report such information to the CTC. The new law, as it will be implemented on January 1st, takes what was simply a requirement to notify, a potential employer about the fact of the CTC report, and actually breaks that down into what I like to categorize as three new duties, one of which is incumbent upon each party in this particular scenario. So I'll try to make that more concrete. First and foremost, under the new law, there is a duty that is now imposed on any and all applicants for certificated employment in California school districts, charter schools, county offices of education, and state special schools. So every applicant to a certificated position in one of these entities statewide must now, in their job application, provide a complete list of every school district, county office of education, charter school, or state special school at which that individual has been employed. What you see here on your screen is taken directly from the statute. And what you see below are some of the questions that we're beginning to see will come up in the future. As the text stands, there is no time bar in terms of how far back an applicant needs to list their previous employers. So absent that, one would assume that this means when they say a complete list of every district, county office, charter, or state special school, it truly means every. And if that goes back 20 years, so be it. Folks will have to do their best, right, to provide a complete and thorough list to the best of their recollection. Secondarily here, the statute doesn't specify what type of employment the applicant needs to have had at those previous employers. So the statute doesn't say provide a list of every district or COE that you've been employed at in a certificated position. It just says provide a list at every entity that you worked at. So conceivably, this as written may include prior employment in classified positions, potentially short-term or temporary positions, and absent clarification from the legislator, right, as this is plainly written, right, it would require applicants simply to list every district, COE, charter school, state special school that they've previously worked at. Another question that's come up, it doesn't list whether this is specific to entities in California or whether one will be required to list prior school districts or offices of education that they may have worked at outside of the state. One would presume that the legislator was intending, right, to focus in on California employers because it's sort of logically inconsistent to believe that somebody would be reported to the California CTC for conduct that took place outside of the state, but that's not clearly written into the statute. So you may want to consult with legal counsel further to see how specifically you want to interpret this as you're rolling it out. But as it's written, it just says every district, county office of education, charter school, or state special school that they've worked at. It's a lot, and it's really, as school business officers, is going to require you to think, pretty quickly about how you want to restructure your application to provide a space for your certificated job applicants to include this information. Now we move on to the additional duties, and these are imposed on what I like to call the previous employer, the school district at which the applicant previously worked at, and the hiring school district. So first, under subdivision C2 of this new statute, we contemplate the duty that's placed on the potential hiring school district. Under this newly sort of designed statute, any district that is considering an applicant for certificated employment, when conducting an employee verification, is now required to inquire with every educational entity listed on that job application as to whether the job applicant was subject to any, credible complaints, substantiated investigations, or discipline, right, for egregious misconduct, specifically as defined in Ed Code, that was required to be reported to CTC. So I'm going to repeat that because I don't want to send folks into a tizzy, and I always want to step back and remember that this is only implicating a very narrow band of misconduct by applicants for certificated employment, right? You are only required to ask, right, whether the applicant had a required, right, report of egregious misconduct to the CTC. Discretionary reports don't fall under this. If it's a CTC report, but it does not implicate egregious misconduct, right? It's a report for other forms of misconduct that are short of egregious misconduct, then the statute doesn't touch that sort of behavior. So this is only a narrow band, but it does mean that as hiring school districts, you will be required, right, when you're doing your employment verifications, to reach out to a long list of prior employers to ask this specific question. Now, the third duty is incumbent on the prior employer, right? If you have previously employed certificated staff that are now applying for jobs in another district or COE, and you receive an employment verification request, the former employer is now required by statute to answer the question, right? Was the employee subject to any mandated report to CTC for egregious misconduct? So you have to say yes, no. And more importantly, and operationally more challenging, is that if the answer is yes, if that previous employee, was reported to CTC on a mandatory basis for egregious misconduct, you also have to provide the potential employer, right, the inquiring entity, with a copy of all relevant information that was reported to the CTC that is, within your possession. So this likely includes copies of the CTC report itself and any supplemental information that's provided as well. Now, many of you who do CTC reports who are on this call today know firsthand that this may include, lists of potential witnesses and other people who have information pertinent to the allegations, potentially investigation reports to the extent that they're not attorney-client privileged, possibly findings letters, incident summaries. There could be a lot that's implicated. And so there is going to be a requirement, right, in these very narrow specific circumstances to turn over a lot of information so that the potential employer has an opportunity to really understand what took place and make a determination as to whether they truly want to hire this employee. Some additional caveats to consider with respect to this third duty. The way that the statute is written, there's an end around the existing requirements of the California Public Records Act. So typically, many of you might encounter a request for this sort of information in the context of a CPRA request from a potential employer, more oftentimes from the media, or from a member of the public who's interested in, potential egregious misconduct or sexual misconduct by former or current district employees. And in that context, There are a series of exemptions that can be relied upon to withhold certain information. And pursuant to CPRA case law, there is certain rights that are attendant to the former or current employee to receive notification about the district's intended compliance with the CPRA and give that person a right to seek a protective order over that information. The new statute here under Ed Code in these circumstances specifically says notwithstanding any other provision of law. So the legislator is effectively saying, we don't care what the CPRA says, right? Per these terms, in the context of employment verifications, right, when you receive a request from a potential employer about a former employee who had a mandatory report of egregious misconduct made to CTC, we don't care what CPRA says, you are required to answer that question, right, whether you made the report and to provide copies of relevant information. So you will likely receive, to the extent that you find yourself in this scenario, a lot of questions early on about, well, I'm going to make this report. The employee is aware and they're telling me not to do so until they can seek a protective order. What do I do? So there's going to be some tension here between, prior practices under the California Public Records Act and what's required under Ed Code. The language in the Ed Code is particularly strong in favor of disclosure, but you'll want to be mindful, right, of this tension and be ready when these questions arise, potentially from an employee who's going to be pretty angry about having this information disclosed, to reach out to counsel to make sure that you can navigate this, right, and that you have the appropriate talking points to be able to tell the former employee, what your obligations are under the law, and to act accordingly. So there's a lot that's going to be going on here. I don't think you'll see it very often because these sorts of incidents don't occur all the time. Again, it's a very narrow band of behavior, but when it does arise, I think it's going to create some degree of anxiety, some potential degree of combativeness between the former employee and the former school district. But these are the requirements. And ultimately, if we take a step back and you all remember as educators, the intent here is a very positive one, and it's to make sure that there's a mechanism by which educational entities can communicate with each other to potentially avoid hiring applicants who have done some pretty serious conduct, right? This only pertains to situations where discipline is taking place or there's been a substantiated investigation. So you're reasonably certain, more than reasonably certain that the conduct occurred, and it lets you intervene, right, fairly quickly to prevent this person from moving on to another position. Oftentimes, long before CTC is able to go through their investigatory process and potentially suspend or revoke the person's credentials. So all in all, right, this is a positive development to allow you to screen out potentially bad candidates. But in practice, it will create a fair amount of work and potentially places for some unsavory conversations with the former employees, and potentially their individual counsel. So here's a brief summary, again, of the three duties, as I like to refer to them. Duty on the applicant to provide a complete list of every prior district, COE, charter school, and special school that they've worked at. And then duties on the receiving, the employer receiving the application, as well as the school district or entity who previously employed that individual and made that CTC report. We'll pause
Eric,
for a second. Yeah.
as expected, we've got many questions coming in on this, but I do appreciate that you emphasize while this is an increase in administrative burden, we want to acknowledge that, but it also boosts transparency and trust, right, in the school systems, and ensures a step to ensure a safe learning environment for our students. So thank you for that. A couple of quick questions here. Do we have to show proof that we reached out to all of the previous districts?
There's nothing in statute that requires record keeping or any sort of proof. The duty is simply to make the inquiry. In fact, the statute doesn't mandate a specific mechanism for making the inquiry. You can send a form email in all likelihood. You can make a phone call. So in practice, you'll probably see a variety of different ways to try to meet this duty. But to the question, there's nothing in the statute specifically, as far as we can tell, that would require any sort of record keeping to prove up after the fact that you made the inquiry.
Does this apply to substitute teachers, subs, and third-party subs or swing?
It applies to applicants for certificated employment. So in the broadest sense, your subs are certificated, and so in all likelihood, yes.
All right, we have one. What if a prior district has a settlement agreement with the applicant that says the district will not share anything negative about the applicant?
Yeah, that is the $1 million question right now. And there will be some place for dispute there. Now, bracketing aside, the fact that this is focused in on incidents, again, where you are required to make a report to CTC. So you're sharing information about the reporting that took place to CTC. So one would presume that even if there is a settlement agreement in place, hopefully the settlement agreement did not, limit the ability to the school district to engage in its mandated, right, legally mandated obligation to report certain forms of conduct to the CTC at certain points in time. So in instances where you do have settlement agreements and it might be a close call, you may want to go back with the assistance of counsel in-house or otherwise to double check, right? What was the nature of the conduct implicated? Does it fall specifically into the definition of egregious misconduct as defined in Ed Code? And did we make a report to CTC? If you're not in that particular space, right, your settlement agreement will likely be controlling, again, subject to close scrutiny by your legal counsel. But you do want to be mindful in your settlement agreements, and this is something to think about prospectively in terms of being careful to restructure your agreements for confidentiality in settlement agreements so as not to limit your ability to share this particular type of information, because you would effectively be writing a contract clause that is invalid per education code if you agree to otherwise.
All right, we're going to take two more questions, and we have a lot of content to cover. We just want to confirm there could have been other investigations done, but if it did not reach CTC, it does not need to be reported.
If it's not egregious misconduct and it wasn't mandatorily reported to CTC, then it doesn't apply under the statute.
Thank you. And finally, on this topic, again, we can reach out to Eric following any more questions, but why can't the school district contact the CTC directly to obtain the information?
School districts can, but there is some lag time in how long CTC will take to provide information. Oftentimes that's related to the due process rights that they're affording to the credential holder as they consider, right, whether to potentially suspend or revoke that person's credential. So this particular statute provides a mechanism to get at this information sooner and allows for sort of peer-to-peer communication by educational entities. So that's a great question. The legislator could have left it that way, and in practice, right, many employers or interested parties would reach out to CTC in the past, not all, but many. But this specific provision is a way to try to facilitate the sharing of information in a much faster way than going to CTC.
Thank you, Eric. I know we're going to move on to SB 848, the leave of reproductive for reproductive loss. Any other questions that are coming in? If we have time at the end, we will address them, but let's move forward with 848, please.
All righty. So moving on, we'll cover a new category of protected leave that was adopted in this state effective January 1st of this year, 2024. So we mentioned this because leaves are always a hot topic. They're a complicated topic, and you have a lot of different types of leave to manage with, both certificated and classified and managerial staff. So this particular statute created a new category of protected leave that's housed under California's Fair Employment and Housing Act, which is the general provision providing for protection against discrimination, harassment, and retaliation on the basis of a variety of protected characteristics in California employment. So what SB 848 did is that it created a new form of protected leave specifically for individuals experiencing a reproductive loss event. What the legislator was intending here, right, and what I think they're truly getting at, which again is an admirable cause, regardless of what we think of it operationally in practice, it's a recognition that human beings are, oftentimes very much invested in trying to have a family, and that there are a variety of ways in which this investment is ultimately, attempted, whether it's a traditional mechanism of having a child within the context of a relationship, whether it is adoption, whether it is surrogacy, and also, it recognizes, assisted reproduction. So what this is saying is, we're invested oftentimes in trying to have families, and again, oftentimes for a variety of reasons, medically or otherwise, it may not work out. And when you're invested in something so dearly and it doesn't work out right, there may have a psychological effect, some degree of trauma, some degree of impact on you and your partner, which may require some time to work through. So what the legislator is doing here is it's recognizing that and trying to provide some degree of protected time off for employees to be able to deal with the fallout from a reproductive loss event. So here, the statute defines it as either, a failed adoption, a failed surrogacy, a miscarriage or a stillbirth, or an unsuccessful cycle of assisted reproduction. So we'll go specifically into what the law now requires. What the law effectively says is for an individual experiencing a reproductive loss event, they are now entitled to protected leave of up to 5 non-consecutive days that may be taken, up to 3 months from the date of the reproductive loss. In a traditional context of, and I apologize for using the term traditional, but the archetypical context, you might think of a reproductive loss as a stillbirth or a miscarriage. That 3-month period would begin to run, on the date of that particular event. And now, in the context of a different type of reproductive loss, say a failed adoption, which takes place over several days or weeks, or a failed surrogacy, or a failed cycle of in vitro fertilization or assisted reproduction, right? Then that 3-month period would begin to run on the last date. So on the day that you were finally notified that the adoption failed, or on the date that you were notified that the reproductive the IVF cycle failed, right? So it's really just creating a new form of 5 days of protected leave that can be taken up to 3 months after this reproductive loss date, and can be taken on a non-consecutive basis. So who does this particular leave entitlement apply to? It applies to what the law coins as eligible employees. You're eligible, right, as an employee for this particular type of leave if you've been employed by your employer for at least 30 days. So this is a much more narrow window of time than you might experience under, say, FMLA, which is a 3-month period. So if you've been with an employer for 30 days, your employer has at least 5 employees, and you've experienced a reproductive loss, then you're eligible for this form of protected leave. This form of leave is also available to the spouse or domestic partner of the person who experienced the reproductive loss. So that particular entitlement is a recognition that it's not just, the person who experienced the stillbirth or the miscarriage who's affected by this reproductive loss, but the partner who's involved as well in that relationship and who is also looking forward to being a particular parent in that context may also need that time, and they are afforded that protected leave. Here are just some key limitations on this particular statute that I mentioned earlier. The leave has to be taken within 3 months of the reproductive loss event. I noted earlier that it's the date will depend depending on the nature of the reproductive loss event itself. The statute does provide that an employee can take more than one allocation of reproductive loss leave within a single calendar year. This may be particularly pertinent to individuals who are undergoing, IVF treatment and may go through multiple cycles in a particular calendar year, or someone who may have attempted adoption or surrogacy, multiple times in a particular calendar year. Those seem like the likeliest scenarios. And so the law notes that you will have multiple entitlements to this 5-day leave period, but you are capped at up to 20 days within any 12-month period. So that's a very generous allocation. In all likelihood, I don't think you'll see many employees, utilizing more than 1 or 2 in a calendar year, but this is the cap that we are experiencing. We noted earlier that the leave can be taken on non-consecutive days. This is an important thing to remember as you're faced with these requests. It doesn't have to be 5 consecutive days. And I think here the legislator is recognizing that individuals may be, receiving treatment, receiving assistance, mental health assistance, and to process this, and that form of treatment may be taking place weekly, biweekly, and so I think there's some flexibility that's intended here by the legislator to allow folks to process in a way that is sort of fitting in with the way that they would like to process this. The final note, it's an important one. It's the bottom right-hand corner of these slides. If an employee or the spouse or the partner of the employee is taking another form of protected leave at the time of the reproductive loss event, the employee would still be able to use the reproductive loss leave at the conclusion of the earlier form of leave, provided that the reproductive loss leave is utilized within 3 months, right? So let me just provide a concrete example. Say you have an employee who is out on FMLA leave, they experience a stillbirth, and they remain out on FMLA leave for another 3 weeks after the date of the stillbirth. Beginning the sort of first day of that 4th week, once they are no longer on FMLA leave, they would now be entitled to take up to 5 days of reproductive loss leave. And that window for taking those 5 days would extend 3 months out. So this is also mindful, right? Something to be mindful about when you're calculating leave entitlements and what they may be able to utilize in the future. Question is going to come up. Are we required to pay employees, or is this unpaid leave? The legislator leaves this up to the province of employers' particular policies. So if your leave policies permit for the usage of other leave entitlements or allocated leave time to receive paid time, then you can make this paid. If there is no policy in place, this leave entitlement can be unpaid. So this is a requirement that you provide access to this time, not that you ensure under all circumstances that this time is paid. Again, similar to the FMLA context, you're entitled to protected time off, but it's not always going to be paid in all circumstances. One other caveat here is that the legislator has noted that an employee may be able to utilize banked or accrued, other forms of paid time off, such as sick leave, vacation leave, allocations, personal time leave, comp leave, to make sure that these 5 days are paid. So it does provide a mechanism for the employee to say, I'm going to use these 5 days. I know we don't have a policy to have these paid, but I have this banked sick time. I would like to use that time instead. Statute does authorize that. So this is, again, a lot to think about in the context of a very tangled web of leaves that you all operate in on a daily basis. So just circle back to legal counsel. Make sure you have a handy reference chart so you remember some of these key points. These 4 boxes here I think are very important to try to remember when you're trying to coordinate leaves. For folks who are on the risk mitigation side of the house, as with any other form of protected leave, right, utilizing this leave is a protected activity. So to the extent that you are retaliating against or discriminating against an employee, treating them differently because they utilized this protective leave, you may face liability as well for retaliation, right, for an employee having engaged in an activity that's protected under law. So also be mindful of the fact that as you would with the utilization of any other form of protected leave, you want to make sure your employees are trained not to retaliate or otherwise discriminate against your employees for availing themselves of this statutory protection. So I know I've offered a lot. Tasha, if you have any questions you'd like to direct my way with respect to the statute, this would be a good time.
Yeah, certainly. So let's start with sensitivity around disclosing the date of the loss. It feels like there's sort of a fine line between personal medical information. Is that required to share the date of that loss?
Well, the employee should be sharing that information with you um, on a purely confidential and protected basis because it allows the employer to determine, right, when the leave protections run. So you do want to know that information. Um, as a gratuitous piece of information, the statute also notes that you are not permitted to sort of share that information broadly. I think it's a common sense piece, right? You wouldn't share confidential medical information, but it does specifically note that that is confidential information. But yes, as an operational requirement, and you may want to think about ways to broach this in a very sensitive and compassionate way, but you will want to try to know when that reproductive loss event occurred, and it's going to be particularly important for situations like a failed adoption or a failed IVF cycle where the leave entitlement begins to run on the last date of that particular incident. So on the date you were notified of the failed adoption or on the date that you were informed that the IVF cycle failed. So yeah, it's important to know, but it will be a sensitive topic to touch upon. And this is where, step away from being the cold calculated lawyer like myself, haha, lawyer jokes abound, and consider, the kind, compassionate educator and human resources professional that you are in terms of having effective scripts to have this conversation so you can get what you have while your employee feels supported.
Thank you, Eric. Does differential apply if they are out on accrued leave?
Yeah, that's a good question, and I don't know the answer to that just yet. So that's something that we're going to have to dig into and we're going to come across and we'll likely have to advise on. If you want to pin that, email me at a later point in time. We can sort of begin to explore that later because the coordination is something that is still being worked out right now.
Can the LEA require doctor's proof?
Required doctor's proof. I want to double check, but my gut response right now is no. Because as you'll see in the context of other leaves, requiring a doctor's note is limited to very narrow circumstances. I don't recall anything specifically offhand in the statute where I saw an ability to require such proof. So I'd want to double back there to make sure I don't misspeak. But bear in mind, right, in the context of paid sick leave, in particular, right, the legislative thumb is on the sort of side of taking your employee's word at face value and only requesting proof in sort of very narrow circumstances. So I'd be inclined to sort of lean that way, but this is subject to verification. I'm sort of speaking off of memory right now, and I don't want to lead you astray.
All right, thank you. We're going to take two more quick questions. We have 20 minutes left of the webinar and a lot still to cover. There's a question around HIPAA laws. The question is, so HIPAA laws don't apply, but there's that fine line of confusion around HIPAA. If you want to address that briefly, or we can follow up later.
Yeah, well, HIPAA would pertain to the disclosure of medical information by specific medical providers. So in this context, I would need to know a little bit more about the specific nature of the question. If you want to put it in the chat box, I think that may help sort of elucidate.
And I'm assuming this is individually driven, but is this paid or unpaid leave?
Yeah,
Is the final question on this?
Yeah, it's going to be specific to each entity. So bear in mind that it can be paid if there's a policy in place that would provide for it. But the statute specifically says if there's no policy in place, the leave can be unpaid. There's only a protection for the time. There's not a protection to ensure that it is paid. But then bear in mind, statute also provides that employees can also credit accumulated sick leave, vacation leave, comp leave to try to make sure that this time off is paid under a different source of protected leave. So the answer is both yes and no, and it's going to be specific to each individual employer.
Thank you, Eric. As we know, this is a sensitive aspect of employee welfare that certainly can improve morale and the feeling of support, but it definitely brings some complexities in how we're managing some of these unexpected absences. So thank you as we move on to workplace violence training.
Great. Thank you all. And this is one that we will gloss over, given that it's a statutory requirement that came into effect this year. My strong suspicion is that just about everyone in this webinar has touched upon the concept of a workplace violence prevention plan in some way, shape, or form, since folks were working diligently to have these plans developed and implemented by July 1st of this year. So SB 553 went into effect on July 1st of 2024. This is a significant overhaul of the statutory structure relating to Cal OSHA. And what this particular statute requires school districts and actually, just about all employers in California to do is to begin to address the concept of violence in the workplace by taking several actionable steps to ensure that there are resources to help mitigate incidents of workplace violence and train employees on how to access those forms of resources. So under the statute, workplace violence is defined pretty broadly, right? It's any actual physical harm or threat of physical harm that is experienced by employees in the workplace. The statute, creates some pretty broad requirements on employers. First and foremost, the fact that employers are required to establish and implement a pretty detailed workplace violence prevention plan, which lists a variety of sources of information about potential workplace violence hazards that exist at any particular employer, what resources exist for addressing the instances of workplace violence, right? It requires employers to establish a system for logging incidents of workplace violence based on a complicated structure of tiers. There are 4 types of workplace violence. The one that's gotten a lot of questions thus far is type 2, which pertains in this context of schools to instances of violence by students against employees, which, yes, these incidents have to be logged pursuant to the Workplace Violence Prevention Plan. And so there's a whole host of information that is now required to be included in a workplace violence prevention plan. We link to a checklist here in the slides that you can access later, or you can contact our firm about. But if you wanted to find additional resources, Cal OSHA has published a model template workplace violence prevention plan. Some additional requirements pursuant to the statute. In addition to developing the plan, there is annual training that is now required for all employees regarding the workplace violence prevention plan. As if you didn't already have enough annual trainings that are required, this is an additional piece. And so you have to ensure that your employees receive a minimal amount of training about the workplace violence prevention plan and the requirements they're under. There are record keeping requirements. School districts do need to maintain logs where they keep track of all violence incidents at the school site. And these logs have to be maintained for 5 years. Additionally, you have to keep logs of when the trainings take place. And all of this information, is readily accessible, can be audited and viewed by Cal OSHA. There will be, penalties for districts that don't and employers that don't follow these requirements. We note here the requirements of the violent incident log, and notably important for public school and public educational employers is the fact that in developing and in revising your workplace violence prevention plan, you are required to engage in consultation with your employees and your employee representatives, right? You are required to speak with employees and unions about the development of this plan. So it is something that's important to think about and that you continually check in about the existence of the plan when you're updating it. As we noted earlier, Cal OSHA is the entity that oversees these requirements. Cal OSHA is working on standards specifically for these workplace violence prevention plans to provide beyond just the additional template plan and log that they've provided to help employers, meet the requirements of the law. There are many good resources that have been developed by law firms that work with public educational entities. So you can contact your legal counsel about those as well if you're in doubt. And so it's just something to be mindful of. I know it's created a lot of headache with respect to incidents of employee or rather student to employee violent incidents, particularly in the context of special education, where a student may not have intended or had the capacity to truly have wanted to hurt an employee, but they did so because of the nature of the disability and how it manifests. But as the law is currently written, these sorts of incidents need to be included in the logs. We recommend that they be done so in ways that de-identify the students, because these logs, are records that can be accessed by Cal OSHA. So again, there's a lot going on here. I know it's created a lot of headaches. To the extent that you're just beginning to address this, contact your legal counsel. There are a lot of resources that are out there, and they're only going to get better. We expect perhaps some legislative revisitation to this, even with some lobbying, just given the amount of operational headaches this has created. But for now, the requirements are onerous, but there are resources.
Eric,
We
only
move
one
on.
question on that, just real quick. Should these plans be board approved each year?
I want to say yes, but I'd have to double check just offhand.
Thank you. All right, we're down to 15 minutes, so we're going to fly through the rest of these.
Yeah, we're flying. So we're down to AB 897, and this pertains to two important changes to Ed Code pertaining to adult school employees, certificated employees, and temps, certificated temps. So with respect to certificated temps, the takeaway from this particular slide is that there are new requirements that are being imposed on the structure and content of certificated temp contracts. Specifically, these contracts, should now include new sources of information, including, the expected end date of the temporary employee's contract, the source of the funding that is being utilized for the temp. This is particularly important for categorically funded temps, and the nature of the categorically funded program. Again, council has been ahead of the game in preparing new templates. Your human resources have likely created new templates. So you just want to be mindful to circle back to your certificated temp contracts and make sure that they are incorporating these new sources of information. With respect to adult school employees, the statute now changes the way in which you calculate the amount of time served for determining whether an adult school teacher is going to receive credit for purposes of tenure loss. So previously, an adult school teacher would receive credit for purposes of tenure if they worked over 75% of the number of days that constituted a full school year for that district. Now, statute has been changed to recalculate that and to note that you would receive credit for that year of service if you work at least 75% of the number of hours that constitutes a 1 FTE position for an adult education program in that district. So it's just calculating, changing the metric by which you calculate the year of service from days to hours relative to a full-time equivalent position for an adult school teacher in that district. This is consistent, I think you'll see, with 44929.25, which effectively states that if an adult school teacher is working less than 60% of the FTE hours, then they can be classified as temporary. So it creates some consistency, at least in looking at a metric of hours, but it's important to go back and look at this calculation. SB 141, this is an important statute that pertains to the recovery of wage overpayments. So for business officials, this is a huge topic. We touch on it briefly, even though it went into effect in the middle of 2023. We like to go back to this because the legislator ping-ponged and it had passed some provisions of law that were very beneficial and helpful to employers, and then immediately in the next legislative session took those back and actually imposed some requirements that are procedurally challenging. So what the statute did, it effectively said that in order to recover overpaid wages, you now need to provide notice to the employee of the wage overpayment and provide that employee an opportunity to respond before you can proceed with attempting to recoup that overpayment. So previously, once you had provided notice, if there was a dispute about that amount, the employers were provided some discretion in terms of being able to go back and start recovering the overpayment amount through salary deductions. That flexibility is gone. So under the new statutory structure, once you provide notice, then you can recover the overpayment in a couple of ways. Number one, if the employee agrees, right, that there was a wage overpayment, there's an agreement about the wage overpayment amount, then you, the employer, are free to enter into an agreement with the employee to, have that overpayment amount returned to the district in any number of ways. It could be salary deductions. It could be having the employee pay installments back to the district. It could also be the crediting of accrued and accumulated sick leave if that's what they wanted to do, right? You have a lot of flexibility when there's no dispute as to the existence of the overpayment and the overpayment amount. Where things get challenging for employers is if there is a dispute. So if you provide notice of the overpayment and there is a dispute about the existence or the amount of the overpayment, then the employer cannot unilaterally, you can't just begin the process of recovering the overpayment amount against the employee's wishes. You either have to come to some form of an agreement with the employee about, whether there is an overpayment and what will be paid back. And oftentimes this means taking a haircut, operationally speaking, right, on that figure. Or alternatively, if you would like to unilaterally begin recovering those wages, you first need to obtain a court order. So this may mean you need to go to small claims court to get an order saying that you're entitled to this overpayment amount. Or if your CBA provides or local rules provide for this, you may be required to go to binding arbitration to get an arbitrator's decision saying that there was an overpayment and what the amount of the overpayment was. Once you have such an order in hand, then you can begin to unilaterally recoup that overpayment amount despite the employee disagreeing. So this creates a big procedural burden for trying to recover overpaid wages. It means you have to spend money, right? When you have an employee really digging their heels in and disputing the existence of an overpayment amount. So this really makes it much more challenging. And it incentivizes cooperation in a sense between the employer and the employee to try to reach some common ground so that you're not ultimately spending more time in employee potentially legal fees to go get a court order that's going to be worth cents on the dollar after you factor in how much time and money it took you to get it. So this is a significant change. You're likely all seeing it in operation, but we think it's worthwhile to re-mention this to the extent that the legislator has moved the bar several times here.
Eric, we do have some questions on that one, and we can decide here live if we want to set up a second webinar because I know there are so many questions coming in, but let me address a few on this particular topic. Can you use work email and communicate the overpayment and potential installment payment in the email and state if we don't hear back within 30 days, we will assume you approve?
You can use work email to provide notice. The statute requires that you provide notice. It doesn't specify the form of notice. Imposing that secondary component of approval by silence is something that could be risky. It is an approach, but you definitely want to make sure you discuss the pros and cons of that with your legal counsel before you go ahead and start taking away, I shouldn't say taking away, but recovering an overpayment despite having had an opportunity to fully understand that the employee truly was on notice and that they're not going to dispute after the fact, a forced repayment here. So we'd encourage you to really discuss pros and cons with counsel there because the legislator is really putting the thumb on the side of sort of mutual meeting of the minds here, right? And either having an agreement about the overpayment amount or having an agreement about what a repayment plan is going to look like. And in the absence of agreement, really pushing employers towards getting an order to validate the overpayment amount before you start taking this money away. So that's sort of the legislative structure as this is written. That's why I say it could be risky to take the approach you suggested, and you really want to make sure you're comfortable and you have the advice of your specific legal counsel there before you try to do that.
And then we have 3 questions around what if there is no response?
Right. So again, that's where you really consult legal counsel. You can try to take the tact where you provide notice again, and note that if a response isn't provided by a date certain, this is what you will do. You can, put them on notice multiple times and say, if you don't respond, we are assuming that you consent, that there's no disagreement here, and we will begin to do this. And that's a tough scenario. So I don't necessarily think that it's unlawful in terms of the way that the law is structured, but it could create risk. You could have somebody come back to you after the fact, and when it's in a court's hands or an arbitrator's hands, you just don't quite know what's going to come out on the other side of that.
I'm going to take one more question on this, and then you and I, Eric, can pull an audible here. What we want to do with all the content that's left. The question is around if they can put the agreement in their new employee packet. Will that cover it, or do they need a mutual agreement per overpayment each individual case?
Yeah, this is something you don't want to address on sort of a global basis early on. The law contemplates that notice is provided on a per incident basis. So each time you have an overpayment, you want to provide notice of the specific nature of that overpayment, give them an opportunity to respond, and then move based off of the options and statute. Doing otherwise, I think could pose some real legal risk for you.
All right, Eric, we have 5 minutes left.
Yeah.
So I would like to, sorry to put you on the spot, but I'd like to know if you would be willing to set up in short order a second webinar that we can cover the rest of this and allow, great conversations as we've had thus far.
Absolutely happy to have a second webinar. Again, we recognize that we have a wealth of information to provide here, and given the significant nature of the first update we provided, and especially the second one, I think the recommendation is well taken, and I'd be happy to come back with folks and address more questions as well.
I appreciate that. We will get that scheduled in very short order. And I'm going to take one more question going all the way back to our first 2534. This one's been sitting out there before we close this. If CTC has already investigated and found no adverse action required and sent a letter to the district, does the district still need to provide the information to the inquiring employer?
Oh, that's a great question. And so if I may revert back to the slide where we take directly from the statute, and this may be something that the legislator may want to contemplate, but as the statute is written, if there is a mandatory report of egregious misconduct to the CTC, then the duty is to provide that information to the requesting school district. If it's ultimately not substantiated at the CTC level, there's some other information that comes into play as a result of CTC's investigatory and disciplinary process. Then the district can, I think in all likelihood, conceivably take all of that into account to determine, whether they would want to hire that individual or not. So I think to the first part of the question, looking at the plain language of the statute and the intent here, it would seem to be the case that yes, if it was egregious misconduct and you were required to report it to CTC, and again, the plain language says, right, credible complaints of or substantiated investigations into, you may have a credible complaint and it may take a turn at the CTC level, but for purposes of meeting the statutory duty here, if you were required to report it and it was, a credible complaint of egregious misconduct, then I would believe that that you would, be required to receive that information from the prior school district.
Eric, thank you. If you don't mind fast forwarding your slides to your contact information so that in the next couple of weeks, if folks have direct follow-up, they can reach out to you. For everyone on the session today, thank you for joining us. There's great questions asked. I really appreciate Eric's insight and the valuable information you brought forward. And for everyone, again, registered, we will be sending you directly the information for the follow-up session with Eric to cover the rest of these labor and employment legislative updates in 2024. Thanks for joining us, Eric. We appreciate all of the insight and valuable information. and we'll look forward to our next session together.
Thank you for having me, and have a great day, everyone. We'll hopefully see you soon.
Thank you.